All right. Well, welcome to tonight's class. Tonight's class is stepping in the second part of kind of what we went over last time with the listing agreement. Now we're going to go over disclosures that would be accompanying that listing agreement and a possible addendum that might also accompany that agreement. So we're going to go over them, what they mean, how to explain them, and how are we supposed to fill them out or our clients fill them out. So all of you have copies of them. First, we're going to start with the mineral, oil, and gas rights disclosure statement. I don't know if... Oh, okay. Sorry, they're not in the right order. So the first one, the mineral, oil, and gas rights disclosure. This is Form 4.25. The MOG is what it's also called by a lot of agents for short, mineral, oil, and gas rights. This form has to be filled out by all sellers with all transactions in North Carolina, with the exception of condos, because condos don't have land. So you can still have it filled out for the purposes of the land that the HOA owns through that condo association. But any other property, you definitely want this filled out. So how would this be filled out? There's 6 questions that the seller has to answer yes, no, or no representation to. Now, as a seller, you have those options, yes, no, or no representation. We'll get more into that also in the next disclosure. But a seller cannot lie on a disclosure, but they can do no representation if they either don't know or don't want to disclose. So the first question on this one is the mineral rights were severed from the property by the previous owner. Yes, no, or no representation. These questions you cannot fill out for your seller. The seller needs to fill them out. You can read the question to your seller and then fill in the appropriate box, but you as an agent cannot fill this out for them. So, were the mineral rights severed from the property by the previous owner? Yes, no, or no representation. If you don't know, that would be that no representation. Next is seller has severed the mineral rights from the property. Yes or no? Has the seller severed the mineral rights to the property? Third one, seller intends to sever the mineral rights from the property prior to the transfer of title to the buyer. So does the seller intend on severing the mineral rights before closing and before transfer of title to the new buyer? Next is going into the oil and gas rights. Were they severed from the property by the previous owner? Has the seller severed the oil or gas rights from the property? Or does the seller intend to sever the oil and gas rights to the property prior to transfer of title to the new buyer? Now, once they have filled those out, the seller, you need to have the property address, the owner's name, and then the owner has to sign and date this. Now, for the buyer, when you have a buyer and you pull these disclosures, hopefully off the MLS that were attached by the listing agent, once you fill out an offer to purchase on this property, there is a question on there that states, has the buyer received a copy of the mineral, oil, and gas rights? And if they have, your buyer is going to need to initial by 1, 2, 3, 4, 5, and 6, and then sign and date at the bottom. This acknowledges that the buyer has been made aware of this form. They understand what the seller has represented, and they have signed off and acknowledged that. Any questions about this form? Nope. All right. Next form we'll go on to is the Residential Property and Owners Association Disclosure Statement. This one is a multiple page document. I'll set these other ones down while we go over this one. So this one, just this past year, they changed it from 4 pages to now 6 pages. So there is a lot more questions that were put into it. Now this one, again, when you have your sellers fill this one out, you cannot fill this one out for them. They have to fill it out themselves. And it is 6 pages of questions about the home, the property, the land, anything like that, and there's 3 options, again, yes, no, or no representation. Seller, again, cannot lie on this disclosure. They can check yes, no, or no representation, and no representation, as it states in the first page, either means the seller is aware of an issue and chooses not to disclose it, or the seller just does not know the answer to those questions. And then yes or no if they choose to answer them. Now, buyers are strongly encouraged when they also make an offer on the property. Again, on the offer to purchase, there's a question about, has the buyer received a signed copy of this disclosure from the seller? If they have, the buyer now has to initial the bottom of every page just as the seller did. And then on the last page, the buyer and seller both have to sign and date it. Now, as a seller, when your sellers fill this out, there's questions as far as, when was the property built? Is the property owner occupied? Is there any problem, malfunction, or defect with the plumbing, electrical, roof, any situation like that? Is the property in violation of any governmental compliance issues, regulations, or zoning issues, anything like that? And then it goes into as far as the HOA. Is there an HOA on the property? And if there is an HOA, are there any lawsuits with the HOA? What is the HOA's dues? What does the HOA's dues cover? Any questions like that all needs to be filled out. If there is not an HOA, then that whole section would be put NA. There is also an NA on some other sections in this form, and NA means that question just does not apply. So a quick example of that is right here on the first page under A9. Is there a problem, malfunction, or defect with the dwelling's patio? If the home does not have a patio, that would be an example of an NA. Does not apply. Just an example. So again, when your seller's filling this out, if they know of any problems, they cannot lie about those problems. If they do not want to disclose them, then they want to check the no representation. Now, a question that always comes up during a buyer's due diligence period. Buyer has a home inspection. Some of these issues that the seller may not have known about now arise and are brought to light. If that buyer were to terminate the contract, seller is supposed to redo this disclosure because now they know of situations, that material facts that are not on here. So the seller needs to redo this disclosure once they learn of these facts from a buyer's home inspection. Or at any time during the process if a seller were to learn of an issue. Say, for example, just a storm comes through and the seller notices a leak now on the roof. If the seller there is no known issues with the roof, that is now a lie. They would have to either change that to yes or no representation. You have a question? Yes.
What's the advantages of the seller filling out a disclosure? Like, what is the purpose of it?
The purpose of this disclosure is to protect the seller. It is not here to help a buyer. It can be useful information to a buyer, but this form is held to protect the seller. How does that protect the seller? If the buyer were to do a home inspection or close on the property and find a problem, and the seller put they did not know of it or no representation, a seller cannot be held liable for that. Now, when the seller fills this out, it does state as of the day the seller filled this out, do they know of these problems. So, big misconception about this form is here to protect your seller. Buyers can use it for information, but the form was created to protect the seller. All right. Another question that always comes up is brokers. If you are a broker and selling your home, how do you fill this out? So you, as a broker, are not supposed to put no representation on this, because if you know of a material fact, you are obligated to disclose that. Now, it says in here that a broker, as also the seller, can put no representation, but if they do and they know of a material fact, they still have to disclose that to any and all interested parties. And also, again, the brokers are not permitted to complete this disclosure on behalf of the seller, in big bold letters on the bottom. Anybody have any questions about this one? No? All right. Next, we will go on to the lead-based paint addendum. Now, this one is only applicable when? If the house was built prior to 78. 1978, magic year. So how is this one filled out? This one gets filled out, of course, with any home built prior to 78, but it is also, I think, one of the disclosure forms that is often not fully, completely filled out. And a lot of that is not because of the seller, but because of the list agent. Because as we go through it, you will notice that the list agent also has to initial it, sign it, and date it. And when you have a buyer, you as the buyer's agent also have to sign it and date it. This is one of the disclosures that both agents party to the transaction both have to sign it. So starting at the top, you'd have the property address and who the seller is and who the buyer is. If you're filling this out for your listing, of course, at this time you don't know your buyer, so that part will be left blank. Next, going down to the seller's disclosure. There is 2 lines here. First is presence of lead-based paint and or lead-based paint hazards. The seller needs to check one of the 2 boxes, that there is known lead-based paint and or lead-based paint hazard in the house, or the seller has no knowledge of any lead-based paint or lead-based paint hazards in the home. They have to check one of those 2 boxes and then initial next to it on the blank line. The second part of the seller, number B, is does the seller have reports pertaining to lead-based paint in the home? Yes, the seller has provided the buyer with all available records, or no, the seller has no records or reports pertaining to lead-based paint in the home. They have to check one of those 2 boxes and then again initial next to that. If the seller has not checked one of those boxes on each and initialed by both of them, the form is not complete and it needs to be completed. So therefore, you would not have acknowledged to your buyer that you have been provided a fully complete form until that is done. Now on the buyer acknowledgement, the buyer has to initial in 3 places. First is the buyer acknowledges receipt of the statement set forth, and then the buyer has received the pamphlet, Protect Your Family from Lead in Your Home, and then the buyer now has to check one of 2 boxes. The buyer accepts the opportunity during the due diligence period to conduct a risk assessment of the inspection of the presence of lead-based paint or lead-based paint hazards, or the buyer waives the opportunity to conduct a risk assessment of lead-based paint or lead-based paint hazards in the home. As a buyer's agent, if the buyer elects to have that done, make sure you do your due diligence and job and make sure that that gets completed. As for the seller, if you have any of these documents and the seller checks the box that they have records or knowledge of any lead-based paint or lead-based paint hazards in the home, that needs to be filled out into these appropriated lines under the seller's disclosure, and you as the list agent want to get copies of anything that would be pertaining to that, because this is again a material fact, so you would want to disclose that to any buyer. Now at the bottom of this page, the buyer and seller will both initial, and then on the second page on the top, agent's acknowledgement. That is where the listing agent initials next to that line, because that shows agent has informed the seller of the seller's obligation and is aware of his or her responsibility to ensure compliance. Now, once that is all complete, the buyer and seller will both sign and date. And then on the bottom, you have on the right side, the listing agent has to sign and date it. And on the left side, the buyer's agent, the selling agent, has to sign and date it. So in order for this disclosure to be fully accurate and complete, all sellers, all buyers, listing agent, and buyer's agent all have to sign and date it. Any questions about lead-based paint addendum? Now these addendums, as a listing agent, once you have these filled out and completed by your seller, when you put the listing up in the MLS, you want to attach these three disclosures to the attachments in the listing. So that way any buyer's agent has the access to them so they can pull them and go over them with their buyer client, hopefully prior to a showing. And that way if there is any questions, the buyer's agent has gone over these disclosures with their buyer. They can contact you with any questions about them. If you do not upload them into the attachments on the MLS, you will get inundated with calls from buyer's agents asking for these disclosures because they will be required to be signed and completed to comply with the offer to purchase when that time comes. Any questions about that? Nope. All right, now we go on to the additional provisions addendum. This addendum can accompany an offer to purchase, and it is used a lot of times with the scenarios that we will go over in this addendum. Starting with the top, you have the property address, the seller, and the buyer. Now this addendum would be submitted with an offer to purchase for that buyer when it comes to the seller. So this addendum would not be something that you would usually use when you're listing a home prior to an offer with a buyer. But it would definitely accompany any offer to purchase that would be coming to you as a listing agent. So we'll go over this addendum. And this addendum you can use with any of these examples. If the example applies, you are strongly encouraged to use this addendum because a lot of these situations are not on the offer to purchase, so therefore they would not be part of the offer unless this addendum is attached. First, number one, expiration of offer. Is your offer that you're submitting have an expiration date? What would be the benefit of an expiration date on your offer? If you're trying to get your offer presented and don't want a seller to just sit on it and hold it for an extended period of time, hoping that another offer may come in and maybe get to a multiple offer situation. Or if you have a buyer who is interested in making an offer on a property and they need to know in the next 2 days if their offer can be accepted, because if not, they want to move on to another property. So if your offer has an expiration date, you would put that in here. It would expire on blank date, at what time, AM or PM, and timing is of the essence. So that is that. Number two, septic system installation or modification. During a buyer's due diligence period, is the buyer going to either have a improvement permit for a septic system or evaluation from the health department in regards to any type of septic installation or modification? Now, if they are, you need to notate that. Is it a conventional system or another type? And also, this form needs to be presented to the seller because the seller is required to pay the cost of clearing the land for the county to do said test. Any other cost that would be accrued for this is the buyer's responsibility, again, unless agreed upon by all parties. But without any other agreements, the cost of clearing the land is on the seller. Any other cost would be the buyer's responsibility. All right? And you want to ensure that a date you put on this would be done prior to the expiration of a due diligence period. Now, if you're having this done, you may want to contact the county, find out how far out they are on doing one of these tests. Because if you have a 3-week due diligence period and the county tells you, well, we're 6 to 8 weeks out, then you may want to have your due diligence period 8 weeks so that way you have time for the county to get out there to do the test, get the results, review them with your buyer prior to the expiration of the due diligence period. All right, any questions about that one? Nope. Next is rental income investment property. The property that is being sold, is it a rental investment property, and is there a lease in place? So if you are buying or selling a property that is a rental and there is a lease or tenant in place or combination thereof, this needs to be attached with the offer to purchase, because this paragraph talks about, when will the buyer get copies of the lease? Is the tenant paying on time? Is there a rent roll that they can get to show how much the tenant pays or how often they pay? Are they current with their payments? Are they delinquent on payments? Is there a security deposit? Who is holding that security deposit? Is there a property manager that's in place that's managing this rental property that's being sold? Who is that property manager? Tenant security deposits have to be switched over to the new buyer or new property manager at time of closing. There is a box here that states, will, if applicable, any pet deposit be turned over to the buyer? That deposit is not required to be turned over to the buyer at time of sale. The security deposit is. So difference in those two. So make sure you know the difference. So security deposit has to also, of course, be held in a trust account. So whenever that gets released, it can be released to the buyer, or if the buyer has a property manager, then it would go to that property manager, but that has to be turned over. So if the property has a tenant or a lease, you want to have this addendum included with the offer, and what date would the seller be required to turn over all of those supporting documents. All right. Next is number 4, agreed upon repairs and improvements. Now, this would accompany an offer. If you have a buyer that goes through the home, sees that the garage door is no longer operable, or it was notated from the disclosures that the garage door is non-operable, and the buyer is wanting to make an offer on the home, but they also want the garage door to be fixed by the seller prior to closing. This would be an example of what you would put in there. This is not a form that you would use if you have your due diligence period and now you're asking for repairs to be done for the seller by the seller prior to closing from issues found during the inspection. This is used for repairs that the buyer knows about prior to contract that they would like fixed or made properly addressed prior to closing. That would be an example of that. Is there any type of repairs or improvements that the buyer wants done part of their offer that is being submitted? Next is manufactured mobile home. Is the property being sold a manufactured mobile home, or is there a manufactured mobile home on the property? If so, this addendum needs to be attached with the offer to purchase. And what is the VIN number, the make, model, and year, any of that applicable information will need to be notated in that line if a manufactured mobile home is part of the sale. Next is pool and spa inspection and preparation. Is there a pool or spa that is conveying with the sale of the property? If so, does the buyer want to conduct a pool or spa inspection on those items? If so, who shall be the responsibility of the buyer or the seller to make the necessary if it has been winterized? So if a pool or spa has been winterized, whose responsibility to de-winterize that so this inspection can be done? Is it responsibility of the buyer or seller? Those boxes would be checked. Now, just because there is a pool or spa in the transaction does not mean that a buyer has to have it inspected. Totally up to the buyer. But if the buyer is wanting to do that, this addendum would want to accompany their offer, so that way it is known up front. Number 7, off-site and or septic lot, boat slip, garage, parking space, or storage unit. Remember, in the listing agreement, we talked about, does the property that is being conveyed have any off-site boat slips, parking garage, storage unit, septic lot, anything like that? If that was checked yes, then this addendum you're going to want to make sure is attached with any offer, because you want to acknowledge that. Is it deeded, leased, seller owned, or HOA owned? And if it is, which item is it we're talking about? And make sure that's all spelled out in the appropriate lines. Next, just so everyone is aware, because it does state in here, if there is ever a conflict between the offer to purchase and this addendum holds control over the offer to purchase on any item that is in this addendum, except the only items that are on this addendum that will not hold over the offer to purchase is the property address, the buyer, and the seller. You would think that would be fairly common sense, but we have to put it in there. But any other item that is on one of these numbers, if there is a conflict between this addendum and the offer to purchase, this addendum holds control. And then on the last page, the buyer and seller both have to sign and date. Any questions about this addendum? No? Very good. All right. Well, we went over some of the disclosures and then the additional provisions addendum. I appreciate you guys being here. And those watching, I hope this was also informative for you, and I appreciate you cluing in and watching it with us. I hope everybody learned a little something, and I want to thank you. And until next time, have a great evening, and let's sell some homes. All right?